Welcome to Dolly Talk. How is everybody doing today? Scott is here. Idaho Mom, how are you doing? Louise. For real. Sorry, I was a couple minutes late. Got distracted. You know how it goes. All right, Botrex has successfully joined the channel. Okay. Well, we have the rest of the Timothy Olson trial. The little rascal was charged with kidnapping a 79-year-old woman, as one does, and holding her hostage for like 16 hours as they drove around. He did some drug deals, allegedly. I need to remove my roller. And he did things like make the elderly grandmother, who may or may not have been into him, drink alcohol. So we're going to get to closing now. And see the verdict, and we'll go from there. Oh. All right, 1 second. Jesus H. Christ, cats. Sorry. I'm trying to see. Crap. Okay. All right, what the hell? What am I doing?
For deliberation. Another outburst from you will be a violation. I've already informed you as to court procedure.
Cats.
I just need the record to reflect the objection not being able to testify to floor comments.
I'm going to turn off microphones at defense table until it's time for Mr. Olson to make his closing arguments.
What?
Okay, bring in the jury.
I can't see when they come in on the monitor. I'm just going to keep going.
Yeah, fair enough.
Bill, you ready? Well, outside the presence of the jury, I'm giving you notice, and it's not to elicit a response for you, Mr. Olson, but I'm giving you notice. If you continue to be disruptive and refuse to follow the court's orders and instructions for you to be quiet when you're supposed to be quiet, I will have you removed and you will lose the opportunity to make closing arguments. Okay, now we're off the record while we wait.
Your Honor, I assume we're going past noon.
Yes.
Okay, thank you.
I did send a message to the chief. I don't know who's reading it, but
Okay, they can only go from 8:30 to noon on Saturday. But we're so close.
we are not leaving.
We are not leaving until we get this goddamn verdict.
On the record, okay, state as to your closing argument.
Thank you. Ladies and gentlemen, I believe I started my opening statement.
I don't care what labor laws I have to violate. I don't care how much overtime the bailiffs get. I don't care how much work my court clerk does. We're getting a verdict today.
This way by thanking you for your patience in advance. And I renew that thanks now as we are here on a Saturday. I truly appreciate all of you paying attention and being patient through these processes. What a closing argument is just that, an argument. What I get to do now is summarize the events as they occurred, as the testimony showed, but in a way to draw it all together. Because again, this trial started on Tuesday. We didn't get to too many witnesses on Tuesday, but here we are on Saturday. One caveat, just like I gave it my opening statement, if you remember something differently, you are to go off of your recollection and your notes. You all had notepads again. They're taken away during arguments because what I say is not evidence. Again, if the law that I say is also not the same as what the judge read, the judge is going to give you a binder at the end of this. So you can refer back through anything. There's a lot of tools and tricks in there to figure out how to go through this process. So you get that entire binder at the close of evidence in order to start your deliberation. So I always like to put the ground rules on first. And then now let's talk about the state of Wisconsin versus Timothy Olson. Ladies and gentlemen, this was Betty Hanel's worst day of her life. You heard her say that on the stand. You heard her talk about what happened. She talked about how it now appears in her nightmares almost every night and why she's able to remember what happened in pretty good clarity, considering it's been 3.5 years and she is 82 years old. She talked through the details of what went on when she was awake. She stated she was in and out of sleep. She stated that she was driven around the city. But let's talk about how we went through and corroborated what Ms. Hanel said, right? First, you heard from Michael Four. Michael Four testified he was in custody. He admitted that. And he said he saw Betty waving from her car. He stopped and talked to Betty where she was talking about how she was kidnapped, how she was held at gunpoint. She went through that process with Michael Four. You then heard from Edwin Roman. Edwin Roman just found a phone in the street. He found a phone in the street. It wasn't broken. He got into it. It was in working order. He tried to find the owner, couldn't find the owner. And then finally, the Greenfield police officers called him, specifically police officer Garrett Olson. Garrett Olson was one of the initial responding officers on the scene. So back on Wednesday, we heard from Garrett Olson. He responded to Grandpa Frank's, 3033 South 108th Street, talked to Michael Four, found the phone from Edward Roman, and everyone at this point was just trying to figure out what would happen. Again, some age bias with these officers. I think that was pretty apparent because they were sitting there talking about how she was just a confused old lady at first, but they still investigated. They then got the Franklin officers involved who appeared on scene. Franklin officers appeared on scene. We heard from Ms. Hanel pretty early on in this trial. Ms. Hanel, one thing, she told you she was 82 years old. I don't think there's any necessarily dispute that she seemed to be an older person. She walked in here with a walker. But sharp, was able to tell you that story, was able to go through those details, had very precise language about what she heard and what she saw. The credibility instruction that judge read is one of the ones that I would like to point out. Who here has something to gain or lose? Who here had precise knowledge, at least to the extent that she was able to recall when she wasn't being potentially forced to drink liquor in a bottle? Who here, 3.5 years later, was able to talk through what happened? Think about that as you're going through all of these events. She was caring for her brother, went to Casa di Giorgio because she had a troubling time with her brother, for one glass of wine, which was her usual, and to read on that Nook book. That Nook book that was found in that back seat of that car, right? Corroboration of what she said. It wasn't just any book. She remembered the Nook book. She remembered the one glass of wine. The Chardonnay bottle. She says she only drinks Chardonnay. Chardonnay bottle found in her car unopened. Where does all this corroboration lead to? So she goes, she sits at the bar. She talks to Mr. Adrizi, the owner of Casa di Giorgio. She talks to him briefly, some small talk. She's known him for years. She's been going there since before her husband died. And then this individual, Mr. Olson, who she picked out in court, comes up to her and sits next to her at the bar, offers to buy her a couple of drinks. She says no. It appears to Mr. Adrizi that they're having some sort of conversation. He's working, though, bartending. He talked about another person in the restaurant. Going through this, when they leave the restaurant at the same time, and again, think of the different perspective of those individuals that testify. Is this an inconsistency? Or is this Rex Adrizi was bartending and he followed her out so it looked like they left together? Think about that. You, ladies and gentlemen, get to bring your common sense and experience in the door with you. You don't have to leave that out in the hallway somewhere. You didn't have to leave it at home this morning. You as jurors talk to people every day. You determine whether or not someone is lying to you every day. You determine the believability of people every day. You get to take that back with you into that jury room and use it. Don't leave that common sense at the door. You talk about this. Ms. Handel then states she gets into the driver's seat, and then you saw her motion, hand in the pocket, like there was a gun. She admitted she never saw a real gun. She was terrified, absolutely terrified. Mr. Olson went from being kind and friendly to vicious. Ladies and gentlemen, one thing you also get to take into account is the demeanor of witnesses in this case. What they looked like when they testified. Their reactions to questions. Don't ignore that either. You don't just have to take words. What they looked like and how they sounded is also very important in this case. Ms. Handel talks about being made to urinate in an alley. Just to bring this up right now, I'll circle back to it later, but Mr. Olson also testified about that. Testified that she had to go right now because you know how women are. And then he also testified that, well, after she went in the alley somewhere on
yeah, I forced a granny to go pee in an alley, but you know how women are. Hey, it's happened to all of us. Don't judge me.
the north side. They then went to like maybe a Chili's or Applebee's down on the south side. So while he made her pee in an alley, excuse my inelegant language, they also then went, after that to some sort of Chili's or Applebee's on the south side.
Well, wanted to get the baby back ribs. I don't blame them.
That was still open, but yet everything was closed.
Oh.
I just how that testimony came apart again, ladies and gentlemen, the believability of that is for you to decide. Ms. Handel testified too that her purse was maybe taken. She didn't know. She was a little bit confused about that, but she knew her credit card was taken and she knew her ID was taken. We heard from Officer Andre Nemish. Officer Andre Nemish was the person that talked to Ms. Handel first. You saw his body cam. You got to see the demeanor of Ms. Handel at the scene. You also got to see how she was moving. Remember Mr. Olson also testifying that she could walk just fine? You saw that video. I'd also like to say this is Exhibit 102. 102, I don't know if you can all see it, but again, as the judge said, if you want it, you can ask for it in the back. Exhibit number 102 shows a lovely pink cane. So clearly she was walking fine, and that was just a decorative device left in the car, probably by Mr. Olson.
It was Granny's pimp cane.
So, ladies and gentlemen, think of all of this again. The credibility of what went together going through all of this. You heard from Robert Handel, again, talking about the demeanor of his mom at the time, what she's like, how she's generally able to be around and lives on her own still. That's great. She knows what's going on. We discussed Mr. Adrisi a little bit, so in interest of time, I'll keep moving forward. Officer Friedbacher conducted that photo array with Mr. Adrisi, who also picked out Mr. Olson, signed that back of that photo, even though he had never seen him before in his life, was able to pick it out of that photo array. Officer Mark Hernan, heard from him. He also responded to the scene. He observed Ms. Handel to be confused and sleepy, found the car keys under the front seat, and she stated to him that the drinks in there were not her own. The officers. Then when Mr. Olson saw officers a few days later, he ran. What did he run with? And I think what's important to discuss too with this is that when he ran, he had a bicycle that was taken from that garage, that building. Again, these jury instructions have a lot of legalese. That building is a garage. He also had those items from that motorized home, that RV vehicle that the Schusters testified to. The shampoo, the e-bike key, that is a motorized vehicle. So And the personally identifying documents, card, the judge mentioned card used to buy things, credit cards. So there's a lot of legalese in these jury instructions to cover a lot of the elements. So again, make sure you read those when you get back there. But I think what we need to point out here is that he ran. He saw officers and he ran. He didn't say, Betty and I know each other. He ran. Let's go through this too. Detective Zaleski downloaded her phone. No evidence in the phone that they knew each other. Some Google voice messages that the defendant testified to, and that he talked about that while she was sleeping sometime in the middle of the night, Ms. Hannell also created a Google Voice account to find out where the defendant went and try to ask him to come back. That's the testimony that was put on the stand. Ladies and gentlemen, how feasible is that? How realistic is that? One thing in the photographs that were put into evidence of everything that Mr. Olson had on his person, those deep pockets, officers talking about how things were falling out because they couldn't find everything. One thing that wasn't found on Mr. Olson was a cell phone. Going through all of this, finding the map that goes through all over the city for almost 16 hours in every inch of the city in no discernible path. Talking about the burglaries that happened in near the area where Mr. Olson was arrested, very close together. Everything here was extremely close together. And then some more corroboration. We heard from 2 crime lab analysts. Melissa Groff talked about the fingerprint. Ms. Molly, this is one of the things too that corroborates what Ms. Hannell said. She was forced to drink from those bottles. They were shoved to her mouth. It wasn't just Ms. Hannell's DNA that was found on the lips of those containers. It was also Mr. Olson's. Mixture of those 2 DNAs. Ladies and gentlemen, Mr. Olson's testimony too, he wants you to believe that they were friends. He wants you to believe they had this relationship. He said that they were there for they knew each other for a couple of years before November 2022. Ladies and gentlemen, a couple of years before 2022 was 2020.
Good job.
So he also wants you to believe in sometime during 2020, they met while he was an Uber driver and a nearly 80-year-old woman was just out for 2-for-1 burgers. I remember 2020. I don't know if you remember 2020, but I'm pretty sure most restaurants were closed during the majority of 2020. Think of all this. Think of everything.
Yeah, she was door dashing her 2-for-1 burgers.
Ladies and gentlemen, when you go back there, read the jury instructions, go through the elements. And at that time, ladies and gentlemen, I would ask that you fill out those guilty forms. It is my burden of proof. So Mr. Olson will go next, and then I will have a chance to get up here one more time. So I thank you again for all of your patience, and I appreciate your time.
Thank you. Okay, Mr. Olson, now is your time.
Okay, hold on
And your
one,
clock has started.
1 second, please. My closing argument is in my paperwork that has been disheveled. It's in the back with the rest of my documents.
Clock is starting.
God.
Oh my God.
Oh my God. Mom. Grumble, grumble,
Where's that? So, as I stated, I never denied knowing Betty Hannell or being with her. So all of the evidence found that places me in cars irrelevant.
And stupid.
As Rex stated, and I thought he testified pretty well, even though I was trying to pay attention. I was a little incoherent at the time from some other issues. But anyway, I did hear Rex, and
You were a little
attorney was
you were a little incoherent. Sir, has there been a time where you were coherent?
he informed me of some of his testimony that he did testify quite well on my behalf, as well as he stated. We left together and we spoke. Me and Betty spoke for almost an hour at the bar, unlike what she had claimed, just for a minute or two. And to rebut what the DA said, sometime within the 2 years before 2022, it wasn't during the time that she claimed when COVID, where everything was closed. But there is a place that Betty goes to. She's the one that, when I arrived there, told me about the buy one, get one burger. I thought that was funny because you buy.
Objection, not in evidence.
Okay. Sustained.
I did.
Was not in evidence. Continue with your closing.
I did.
Oh, whoops. Sorry, guys.
I did. And
I was messing on another tab with audio, and I guess it messed up this audio too.
and to rebut what the DA said, sometime within the 2 years before 2022, it wasn't during the time that she claimed when COVID, where everything was closed. But there is a place that Betty goes to. She's the one that, when I arrived there, told me about the buy one, get one burger. I thought that was funny because you buy.
Objection, not in evidence.
I thought it was funny because you know you buy one burger and you get one free. I bet she was a real. Oh, I bet she just loved buy one get one night at B-Dubs.
Okay. Sustained.
I did.
Was not in evidence. Continue with your closing.
I did.
What that bitch talking about? My buy one get one burger ain't in evidence. Objection. But it was a good burger. I swear it was in evidence.
So, as I had stated in my testimony, I talked about meeting Betty at this restaurant bar.
Well, here's the important thing. Did the burger come with bottomless fries? I'm just saying.
And as I had stated, Rex clearly noticed my demeanor at the restaurant and that I was well dressed and well mannered. I'm never a vicious or violent person. Anyone that knows me knows that.
I was well dressed, well mannered. I wasn't acting like I'd abduct a 79-year-old woman.
We left together, like I said earlier yesterday. When I walked out, I was going to go get into the passenger seat, but her door flew open all the way and she couldn't shut it, so I went and shut it for her.
Aw.
So this is if there was a camera outside, this would be.
He's a gentleman.
This wouldn't even be here right now. As a detective testified, he didn't even bother to investigate camera footage, and it's such a serious allegation.
He didn't even look on Groupon for any buy one get one burger Groupons that were available.
I mean, there's no footage of anything that would resemble a kidnapping. I asked the detective if he would turn over his version of the phone so I could have it investigated even by the FBI. Why wouldn't that have happened if there was nothing to hide?
Objection. I'd ask that last sentence be struck.
Well, to the extent it's closing, I'm going to just allow it. Let's continue.
I also asked for all the photos that he had to be turned over of the car, so that because there was one missing, he denied to do that. Why? This is very odd in such a serious investigation. My interrogation was not used, which if anybody watches like 48 hours, that's pretty rare.
Action, not in evidence.
Sustained. Continue.
The detective perjured himself on the stand numerous
Objection,
times.
relevance.
To the extent that this is closing out loud, but continue.
Am I going to get more time for these objections?
Continue, please.
As I said before, the detective didn't thoroughly investigate this for a reason, because he knew as well there was no crime committed. There was more evidence that this was not a crime. As I testified, me and Betty went to several locations, and I even went into stores on her request to get things, fill up gas in her car.
Aw.
She gave me a birthday card, a Thanksgiving Day card. She gave me some money.
She gave him a birthday card? What a class act.
When I first entered the car. I knew many things about her personal life because she shared that with me over time. And as far as using the bathroom, like I said, I testified to the gas stations in those areas don't have bathrooms that are open to the public usually, so she couldn't wait to go anywhere else, and that was all that was. It was not. It was very odd to me as well, but
you know how women are.
I really need to stress about requesting the original phone download from the detective, because as I stated before, that the Google Voice, and there was text from Betty to me asking me where I was, if I was coming back, and I've stated that from day 2. I called the media.
Objection, not in evidence.
Well, continue, finish.
I called the media and let them know about this text and my innocence on day 2, Channel 12, and another reporter.
Now the objection is sustained.
All right,
That it was not in
okay.
evidence. Continue.
You did call the meeting, sir.
There's no evidence of any that I physically restrained anyone, and there was no. So I know in here it states that the where's just because there's a reasonable opportunity to escape doesn't change confinement. There was nothing to escape from. I'm not a violent person, and I would never mistreat an elderly person that way.
I even let her go to the bathroom.
My family, my mother, who is, elderly as well, and that's just absurd that I would be charged with something like this. I spent.
Objection. My mom is old, not guilty.
Anytime talking with Betty about my son, grandchildren. This is a very serious charge, and I would hope that you would all look at everything and know that I'm not the one lying. There's things that were lied about, and I've tried to get this out for quite some time. I would also just like to state that you all can make your own decisions regardless of what these court rules are or any other rules they put in front of you, especially my right to have a fair trial, which was completely stripped of me.
Objection, Your Honor, arguing for jury nullification.
Sustained. Do not do that, Mr. Olson.
Count 4, which is the burglary of the alleged burglary of the garage. In order for there to be a crime, In order for a crime to exist, there must be an injured party. And since the injured party was no longer with us and no longer able to be here, that one's a no-brainer. It's even though his sister came, she's not the lawful owner. It has to be the injured party.
Objection misstates the law.
Sustained. Do not misstate the law. Continue.
That is consent to the lawful possession.
No commentaries.
It also has to be an intent to steal. There's no way that anyone can look inside someone's head and say they intended to steal. So just on those grounds alone, it's just virtually impossible for a jury to decide that. As I wasn't able to testify to that, but I believe I spoke to question Detective Zalewski about this. I did know the owner of the RV, and I was in that area for quite some time.
Objection, not in evidence.
What?
So overruled.
Hey, moments.
Continue, please.
She did survive, and she testified earlier. But he still abducted her for 16 hours.
I was not allowed to testify about the other counts. It's also a violation of my right to a fair trial. So I can't discuss any of those points. Is that correct?
The court cannot give you guidance on what to say at closing arguments.
The court could take away my rights. As far as the obstruction, I questioned him about that. There was no obstruction. I started to get on the ground. The officer came up behind. I've never been a violent person or one to resist like that. So
You've been resisting the entire time on trial. You've been pissing off the judge. You've been pissing off everybody. You bashed your head into a wall and had to go to the hospital, I believe, twice before trial started. Trial was delayed 2 or 3 times because you had to go to the hospital. You'd get cleared medically. You representing yourself requested a competency hearing, by the way, and had the wherewithal to have your standby counsel handle the questioning of the witness, the doctor, on your behalf.
He tased me in the back of my arm while I was getting on the ground, or while I was already on the ground, which surprised me. Luckily, it didn't do too much damage, just kind of shocked me a little bit.
Yes, stun guns will shock you a little bit.
No obstruction, as they told. Too bad there's no video, or else you would know that for sure. And if there was any video more, if you would have done more investigation, we wouldn't even be sitting here. I've sat in this courtroom trying to fight for my rights.
To party.
I really need to emphasis on count 1 and count 2. Count 2, there was no intent of anything in count 2 with the misappropriate use of ID. She was with me. She let me use the card. As I stated in my testimony, she gave me one of the cards to use to go inside, which was why when I got out of the car and left abruptly, I still had that card with me. We were supposed to meet up anyway later on in the day, as I had also stated in my testimony on Thanksgiving after she met her brother at Nader's. I have to stress on count 1. This is very serious and something that I believe is just absolutely ridiculous. And there's no evidence of me forcibly restraining anyone or anything like that, because it just didn't happen. And this is why Detective Zalewski did not properly investigate this. If I was an officer and I was investigating a crime like this, I would make sure I got all the videos so I could see if this person was injured, harmed, what else was happening, to see if there was a gun, something. I mean, that really goes to show a lot. And I have to restate the text in the Google.
Yeah, believe it or not, I have never once had an issue with YouTube captions not coming up. Even when I'm like shocked, it can actually make out what they're saying. This guy is an exception though, because for the first time, YouTube could not figure it out. So
voice, if this would have been investigated by this detective, he would find that it was Betty Handel's account, and I don't have passwords to her accounts. It's pretty easily investigated.
I totally know that her password is not password1 with an uppercase P.
And that's not me. It was also clear that Detective Zalewski was avoiding talking about the phone download. There's a reason for that. The reason why I stress this is one of the reasons why I'm representing myself, is because no one would go after these texts or subpoena Betty Handel's phone records, which would have easily shown there's a text missing from the phone download.
Sir, the reason you're representing yourself is because you could not convince 7 lawyers to lie for you and present evidence they know is not true. That's kind of a pesky problem when you want to lie to a jury. You can't get a lawyer to lie for you. And now they can do a lot of shady shit, and they can do a whole lot of loopholes and try to show doubt, but you can't have them outright lie for you.
Tried getting this for almost 4 years.
In relevance and not in evidence.
Sustained, and that's correct. Continue on.
Oh, and Betty at that time was not using her cane. She didn't bring it into the restaurant when in Casa de Giorgio. So it was in her car. I think I noticed as well. But she didn't use it. She moved around quite easily. So the items that I was found with is clearly not something someone would enter somewhere to burglarize for. This is where like gold watches, or this was, you're talking about like a pack of Skittles and some marbles. That's not what the items were, but I'm just saying this is ridiculous.
Has the FBI gotten involved? No, I don't believe Kash Patel has showed up on the scene yet. But once he gets some Epstein convictions, I'm sure he'll be right over there.
These charges are all absurd. Again, the amount of things that I knew about Betty's family and past, and I could have only known by knowing Betty, that she had power.
Yeah, you can only know this stuff by knowing Betty, or having your discovery for 4 fucking years. But I'm sure it's your budding friendship with a 79-year-old woman.
Power of attorney over her brother's affairs, or her sister.
Okay, once Kash sobers up and doesn't have a hangover anymore from celebrating Olympics hockey, he'll get on it.
Embezzled money from her brother because he was sick of, I'm not sure what was wrong with him, but and that she had passed away and she was younger than Betty. She made that known that the sister was younger, that she had already passed away. For such a serious allegation, I like all of you to think about some of the things that, some of the testimony that was back and forth. I slept all night. I was up all night. Or Detective Zalewski claiming that I claimed I was Wes Erdman and then recanted his statement. I'd like all of you to use your common sense as well and realize who's lying here. And I'm not even referring to any of the alleged victims. They're clearly hiding things. And you can tell from their facial expressions.
Huh?
I've also like all of you to know that I've contacted the FBI to investigate some of these matters, and I did state this on the record.
In evidence.
Correct, not in evidence. Move on. Time's up. Okay, state closing. Your last word on the closing.
Thank you. Ladies and gentlemen, just briefly. He's such a nice guy. He left a 79-year-old woman on the side of the road without her cell phone, waving for help after an argument. But he never is angry. Ladies and gentlemen, just think of everything. Think of this case as in total. I think the one thing that Mr. Olson and I might agree upon is that this is serious. You need to make sure you look at the instructions. You need to make sure you evaluate the evidence. You need to give the time which it deserves. Go through those jury instructions. And just think of things like the jury instruction you'll also get. It's called the burden of proof. You're going to search for the truth. You're not to look for doubt. You are to search for the truth. So last line in that jury instructions, and ladies and gentlemen, just remember the evidence. Remember Mr. Olson giving a fake name at the time he was arrested. Remember Mr. Olson being arrested with that credit card of Betty. Remember all of these small little details that draw the witness's testimony together. And then I would ask that you would find him guilty of all the charges. Thank you.
Members of the jury, you are to decide this case fairly and impartially, without fear or favor, and without passion or prejudice. You are to decide only whether the defendant is guilty or not guilty of the offenses charged, and the consequences of your verdicts are matters for the court alone to decide.
It was quite quick.
And on behalf of Milwaukee County, State of Wisconsin, thank you for your service. Please wait. You can be seated again, and then wait until the deputies take all of the jurors back, and then thereafter you can depart at that time.
Uh-oh. Almost spoiled it.
And Timothy Olson. I would please take the way to leave.
And the wrong.
Okay. Yes, you can remove him.
I don't know if they got lunch. Oh, hey, ours. Oh, great.
Okay, we're on the record outside the presence of the jury. In my reading of the jury instructions, I realized that page 30 of the jury instructions, or count 2, that instead of...
Crap, did I go too far? I'm sorry, guy. I had the timestamp, and the timestamp was freaking wrong, I guess.
Another reading, we the jury find the defendant. Another reading, we the jury find the information. Junior, the jury charge and content type of the information. Another reading, we the jury find the home as under account. This is a criminal, not a deed.
I'm sorry, guys. I had the wrong timestamp.
7, can you stand?
Okay, here we go.
Join the rest in deliberations. I do want to thank you to these review on Monday. The mic.
Right.
Mr. Olson, you need to stop. Mr. Olson, you've been ordered by the clerk to stop talking. Okay, yes, you
I
can
think it
remove
would
him.
be Stephen. I love the look he just gave the camera. Easy there, Hasselhoff.
By the presence of the jury. In my reading of the jury instructions, I realized that page 30 of the jury instructions for count 2, that instead of saying kidnapping, it should say unauthorized use of personal identifying information or documents. I read it correctly, but I'm going to make that change so that the printed version of the jury instruction is consistent with what I read. And then, Deputy, you can come back and take the binder for the jury.
After closing arguments, right there.
Yeah,
After
Sir,
closing arguments.
that pink shirt does not do your breasticles any compliments. My God, you need a brassiere. Ugh.
much
That's cold in there, apparently.
after closing argument, not immediately after. Hi, Chief.
Oh, Jackie, thanks for showing this. Oh, you're so sweet. Thank you so much. It's
Chief, how are you?
been a lot of fun. I've really enjoyed this one.
But it was really nice to just be.
We're on the record outside the
Oh,
presence of the jury. Mr. Olson, you are instructed by the.
Okay. Hold on. Okay, my cat just knocked my trash can over. 1 sec. I'm sorry.
Court to not speak at this time because there is no need for you to place anything on the record at this time. I understand you want to file a motion. There is an opportunity for you to put in any motions you may have. That's done after the verdict, okay? So I understand there's a verdict. We'll bring in the jury. By the way, we're outside the presence of the jury. Will the presiding juror please stand? And your jury number? 11. And has the jury reached verdicts? Okay. I will take a look at the verdict forms.
Oh, not guilty.
Right, and juror 11, is it correct that the jury reached unanimous verdicts in these counts? Okay, at this time, I'm going to have Mr. Clerk publish the verdicts. After he's done doing so, he will poll each of you to ensure that these are, in fact, your verdicts.
We, the jury, find the defendant, Timothy Olson Jr., guilty of kidnapping, seizures, or confinement or stability, as charged in count 1 of the information. You find the defendant guilty of kidnapping, you must answer the following question. Did the defendant commit the crime of kidnapping against a person
Guilty.
60 years of age or older?
F's in chat.
We, the jury, find the defendant, Timothy Olson Jr., guilty of unauthorized use of personal identifying information or documents of greater value as charged with count 2 of the information. If you find the defendant guilty of kidnapping, you must answer the following questions. Did the defendant commit the crime of kidnapping against a person who was 60 years of age, 60 years of age or older? The answer is blank. We, the jury, find the defendant, Timothy Olson Jr., guilty of obstructing an officer and charged with We, the jury, find the defendant, Timothy Olson Jr., guilty of burglary of a building or dwelling and charged in count 4.
And shitting in a motorhome.
And we, the jury, find the defendant, Timothy Olson Jr., guilty of burglary, mobile home, or trailer home, and charged in count 5 of the information.
Mr. Clerk, before you poll, can I see the verdict forms again?
What is this world coming to?
Okay, members of the jury, with respect to the verdict that was turned in for count 2, the verdict form that was turned in as your verdict and as your unanimous verdict is obtained.
Okay. We can try to watch his sentencing. The audio is kind of messed up, but I may have it. Closed captioning, I don't think it's going to work for like 20 more minutes.
Timothy Olson is present in the courtroom, in person, in custody. Standby counsel John Vasilevsky also appears.
I'm objecting because my microphone is off, just like she turned it off during trial, so I couldn't object.
Mr. Olson,
I'm objecting.
I'm gonna,
Microphone off.
okay. This is the second time I'm trying to have this case called. If you interrupt me, I'm going to have you removed, okay? This case proceeding is not for you to control.
But
I've already explained that, okay.
I have to be
Now,
allowed.
Mr. Olson?
Your Honor.
Okay, we're gonna have you removed until you can comply with the court's rules of decorum, which you are aware of. Do not speak over one another. You are to wait until the court asks you a question. We can barely get through appearances.
You're violating my rights.
Okay. Remove Mr. Olson.
like you did
You'll be
for
given another
trial.
15-minute break, and then if you can comply with the court's rules, you'll be brought back 9:28.
Violating every code of conduct you can think of. You're not gonna violate my rights.
This is Democracy Manifest.
Okay, we're back on the record in the Olson matter, just so the attorneys are aware. The court will give him another.
Oh, this poor judge. It's Monday morning. He has to now sentence this guy.
I gotta get out of here. I think I'm gonna lose it.
Uh-oh. Sounds like somebody's got a case of the Mondays.
Chance, and if he continues this, we will then put him on Zoom, and he can appear on Zoom for sentencing.
Can he?
To ensure that he's going to waive his right to appear in person should this behavior continue. So to that end, the legal parties can then prepare accordingly for a Zoom appearance in the event that Mr. Olson does not comply with court rules. Okay, we're off the record.
Okay, so he's in his naughty boy timeout room.
Is Zoom setup still back there, or did Mike Poop take it out already?
Did they prematurely take Zoom down? What's going on here?
The Luther 22 CF 4696. Appearances again.
Sarah Sadowski appears for the state.
Hey, I'm
Timothy Olson.
What are you doing?
Okay.
I'm gonna ask that you ask your deputy not to assault me. I was grabbing the microphone.
Okay.
Get your hands off my penis. He touched my penis. What is the charge? Eating a succulent meal?
It's unnecessary.
Wilson, you need to stop.
It's unnecessary.
Unnecessary penis grabness. 5-yard penalty.
Appearance, please.
Appearances, Timothy Olson appears in court in custody, pro se, in person. Is it, standby counsel John Vasilevsky also appears?
All right. Good morning to everyone. This is the third attempt that the court is trying to have this case called. We finally got past appearances just now. It's now 9:57. I did have Mr. Olson removed at 9:28, so more than 15 minutes was given to Mr. Olson to calm down. Mr. Olson, I'm letting you know that if you failed
Objection! I wasn't pissed off.
to follow the court's rules of decorum and you continue to be disruptive, I will have you removed and you will appear on Zoom for sentencing so that the court can okay. I'm not done talking. I'm letting you know
Put his hand up,
that
Your
your
Honor.
disruptive behavior, if it continues, will result in your removal. It does not prevent the court from continuing with sentencing, and I intend to complete sentencing today. You will appear on Zoom. No, you may not. Okay, Mr. Olson, I'm going to have you removed, and you're going to appear on Zoom.
God.
Hey, can you make sure this either goes with you or goes into the file? That's this is the envelope full of the big black guys that I have to have it analyzed.
We're off the record.
Did you put those into? Okay, hold on. Did you put those on the file? The motions?
No, from court, you need to stand up.
Mike, who's back there?
Okay. He did come in.
Mike, who's back there?
He did come in. I'm not sure if he's still
Okay.
out there.
I did let in 6:35.
That was nice.
The video is, the camera is blocked. Or covered, I mean. Wait, do you need the TVs turned on? You have, is that Attorney Oldigan? No, I want to place that on the record so that way there are no allegations. Mishandling.
Oh,
All right.
happiest that lawyer's been in a while. Have another person sit next to him.
Attorney Lonsky, we are calling Gaines from yesterday, from March 16th. State of Wisconsin versus Quartarius Gaines, case number 25 CF 3006.
Oh,
Appearances.
got a different case going. I'll be right back. We'll be right back. Timothy Olson is in a naughty timeout.
Yeah. 4696 appearances again.
Sarah
You can
Sadowski appears
communicate.
for the state.
Timothy Olson is in custody, pro se. He is visible on the Zoom screen in the holding cell behind the courtroom. Attorney John Vasilevsky, standby counsel, also appears.
All right, good morning to everyone. Due to Mr. Olson's continued disruptive behavior, which prevented the court in proceeding with the sentencing, he was removed and now appears on Zoom. His audio on Zoom is muted and will be unmuted when it is time for him to speak. Okay, so before we go any further, I had asked Attorney Wasilewski to just look at the new motions that Mr. Olson has prepared and wants to file with the court. I think as a matter of procedure, in terms of timeliness, what are those motions, counsel? Have you had a chance to look at it?
Yes, I have not read them word for word, but I have viewed them enough to have an overall feel for what they are. There are two documents. The first one is 14 pages in length. The second one is 20 pages in length. They all purported to be directed not only at the circuit court.
Wait.
The first one is 14 pages in length. The second one is 20 pages in length.
Oh, I bet it's no more than 6 pages in length. Men, right, ladies?
They all purported to be directed not only at the circuit court, but at the United States Supreme Court, the Wisconsin Supreme Court, the Wisconsin Court of Appeals. In addition, the 20-page document is purportedly addressed to the Federal Bureau of Investigation, the U.S. Attorney, and various what are characterized as internal affairs departments. Each of them contains at least 20 numbered grounds. Some of them are in a single sentence. Some of them are a little longer. Most of these grounds allege improprieties or misconduct both before trial and during trial. Improprieties or misconduct by the court, by the prosecutor, by me, by various court personnel, by prior counsel. That would be my summary of what I reviewed.
Okay, so now that I know that, I do want to circle back and go to, I'm going to refer to them as document 170 and 171, but those are the two motions that Mr. Olson wanted to file on Saturday when we were in trial. They have since been filed. The 15-page one-sided or single-sided motion is document 170. The 2-page is document 171. I have read those motions, and Mr. Olson, you are the movant, and so I'll give you an opportunity to place on the record explaining what you're asking of the court and the basis you have for what you're asking, and you're to limit what you place on the record on that. If you go off on a tangent, you start talking about something else, I will mute you and then we'll continue. But I'm letting you know that your continued failure to follow the court's rules of decorum, including when the court directs you to pay attention and focus on what's at hand, will result in your Zoom being muted. Okay, so at this time, let's have Mr. Olson unmuted, and I want to go one motion at a time. The first motion is the 15-page single-sided motion, which I refer to as document 170. That is the white packet here. The other one is the yellow paper here. So let's start with the 15-page on white paper. As to your motion, Mr. Olson. Hold on, you have to be unmuted. We can't hear you, but I can tell you're trying to say something.
I have no doubt.
Okay.
Yes, we can hear you.
So I would have to ask for those copies of those motions before actions so I can go over them, because I don't have copies of them. I wasn't able to make copies because you placed me in a hole.
Okay, hold on. Yep, we'll bring it back.
I would ask that all.
Mr. Olson, just wait until you have your motions. Okay, so starting with the white 15-page motion.
Yeah. Okay,
Go
I
ahead.
just need to clarify for the record that this 15-page motion was submitted, I notified the court on Saturday, March 14th,
prior to my testimony that this needed to be submitted. The second motion was the one I wanted to submit later on, but the court made it seem as if the 15-page motion was submitted after,
Okay, let me direct your attention, Mr. Olson, because you're not really answering my question relative to what you want to put on the record in support of your motion. As to the 15-page motion, what are you asking of the court?
I'm asking the court for a mistrial and to dismiss charges.
Okay, and then the support for that.
Well, the jurors were talking in the hallway, at least 8 of them in front of the elevator. They actually tried to get in on the elevator with me. Several of them, they were all in the hallways talking about their case. Your deputies were talking about it. I know for sure Deputy Rivers was texting about the trial during the trial. This was on 3/11 and more days than that, but for sure I heard him talking about it then. Also, I noticed that the DA and yourself were communicating via cell phones during my trial with texts and calls.
Right.
I was also informed by other clients of CI Thomas Fisher that the DA was informing that the DA informed Thomas Fisher that she was bribing you to conceal the text and misconduct that she's been committing. And I'm asking them to be fully investigated by the FBI. All phones, yourself, DA Fidelity, your deputies, and the jurors, including Attorney Wasilewski, these phones need to be downloaded and this needs to be fully investigated because this is very serious. And the text that it's generating exists, and the DA perjured herself on June 16th when she asked Attorney Wasilewski if he received the redacted version of the phone download, then claimed there was never a redacted version. And I believe it was October 24th or November 24th, the hearing in November or October of 25, the DA refused to answer what she gave Attorney Conradi on February 14th, 2024, when she gave over the unredacted phone download, which the DA and the detective claimed there was no unredacted version and you couldn't redact or unredact. This is all one big lie and it's provable by perjury committed by both of them during trial testimony and transcript that I had requested. And DA Fidelity intentionally gave us flash drive that wouldn't open, and Attorney Wasilewski testified to this in court that he tried it on his computer. Now, these are because permissions can be given to open those flash drives on other computers or not given. This is why it wasn't open for us and it would open.
Okay, Mr. Olson, I'm going to stop you there for a minute. In all fairness to the state who has to respond, well, they don't have to respond, but they will be given an opportunity to respond. And having read your motion, you should not bring into your motion new things that you did not give notice to opposing parties. So to the extent that some of the things you're talking about are not contained as part of your basis or support of your motion, try not to talk about those things, okay? All right, continue and try to sum it up because I'm going to move on and have the state respond. And when I do that, I'm going to have you muted.
Oh, it's like
All right, the deputies were purposely parading me through the hallways instead of going the back route. Any other time before trial, we never went through the front like that. But all of a sudden during trial, I'm being paraded through the front. Even during a medical emergency, I would walk out through those hallways with covered clothes. I was incoherent, and this is one of my main reasons for a mistrial. I was brought into the courtroom, and they knew I was incoherent from puking in the back. I had a seizure in the back when a different deputy, wasn't Rivers or Bruce, were back here. I had a seizure in the wheelchair. I was driving. They knew I was incoherent in the courtroom. I was not even able to object or respond because of the severity of the concussions. I'm not positive, but I believe on Wednesday, the 12th of March, during the third day of trial or second day of trial, I believe I had another seizure in the cell and made the head wound on the head worse, which is this is when Sergeant Wilborn took pics of my head wounds on
Okay, Mr. Olson, I'm going to have you muted. And
Poor guy.
now that you're muted,
Is it something you said?
I'm going to invite the state to respond. In reading document 171, which is the 2-page yellow paper that you also filed, you provide mostly, if not all, the same basis for that motion that you did for 170. So I'm going to turn to the state and allow the state to respond as it relates to the motion to dismiss and or in the alternate motion for mistrial. To the extent that document 170, which is the 15-page, is addressed to Chief Justice Joe Krofsky and other entities and organizations, but other entities. But I think to the extent that it could be interpreted as a petition for supervisory writ, the trial court is not the proper forum for that. That should be filed under should be filed with the Court of Appeals under 809. And so setting that aside, construing 170 and 171 together as a motion to dismiss or in the alternate motion for mistrial, state your response. If that makes sense, what I'm saying for the record. There's a lot of people who are named and many people who these motions are addressed to. 170, I think, could also be interpreted as defendant's petition for supervisory writ. And to that extent, the trial court is not the proper forum.
Right. And I was going to say, none of them necessarily seem to be addressed to this court either way. Additionally, none of these, Mr. Olson was able to verbally argue all of this in his motion at the close of evidence. So I think also these are untimely, even if we would have addressed them before the final verdict. So there's no new information here. This is untimely. It wasn't addressed to us. It's not the proper forum. It's after the judgment of conviction. And frankly, parties cannot make wild claims without any factual basis. And so I think that is also a reason that these should either be, that these should be dismissed or they can be filed for review upon a different court.
Okay.
I don't want to deal with it.
In trying to make sense of these motions, it's clear to me that Mr. Olson is unhappy with the trial court's decisions. And he's certainly entitled to be unhappy. As a matter of fact, many times people are unhappy with decisions of the court. But
I often leave
by
my
no
partners
means
very
does that mean that Mr. Olson can repeatedly ask the same court to reconsider its decision. And so I think another angle of this is that to the extent that Mr. Olson is requesting the court to reconsider its own decision, he doesn't provide a legal basis for which the court can do that. Many of the grounds or basis that he provides in support of his motions, whether it's document 170, 171, are basis or allegations that the court has already addressed previously. At milestones of this trial, Mr. Olson was invited by the court to make any motions of the court, and the court specifically at the close of the state's case in chief indicating that this is a sufficiency of the evidence standard. And then again, at the close of all evidence, indicating that it is sufficiency of the evidence. That being the case, the grounds for which Mr. Olson puts in support of his motions do not address the sufficiency of the evidence, but are more along the lines of his grievances towards the trial court, as well as anyone else who's touched his case, whether that involves prior counsel, standby counsel, or the state. And thus, these motions are untimely, and the trial court is the improper forum relative to document 170. And I think the court has more than on more than one occasion has been willing to entertain Mr. Olson's motions, but
John Bolton's there thinking about, oh, I wish I could bomb Iran. Oh, wait, we are.
Has simply come to a point where enough is enough. This has just been another tactic of Mr. Olson to delay.
Enough is enough. There's so much sexual tension in the air.
The court in closing out this case, especially now that we're at sentencing. And so for all those reasons, document 170, the court will, even if it's not construed as a petition for a supervisory writ, that must be filed with the Court of Appeals. That motion, if it's construed as a motion to dismiss or a motion in the alternate motion for mistrial, denied by the court. For all those reasons, the court placed on the record document 171, the 2-page motion, also denied for all those reasons placed on the record. With respect to the unfiled motions, it sounds like to me, based on the description given by standby counsel, for purposes of the record, we can pull it in, but the court's not going to address it because many of those grounds and bases sound like the same grounds and bases provided for motion document 170 and document 171. To the extent that Mr. Olson can raise those issues on appeal, he may do so. But I think for completeness of the record, those motions can be received by the clerk, and the clerk may receive them violent in the record, but the court will not address them for all those reasons. Okay, so now we're going to move on to sentencing. And State, are you complying with victim notification?
Yes, we have victim notification of all victims. There is no victim impact statement that the state is filing at this time or restitution request.
And just so we're all on the same page, I did go through the counts, and I'm confirming with you, State. Count 1 is a Class C with an enhancer. By the way, I sentence in months, just so you know.
I'm sorry, what was that?
My sentencing, I do it in months, not years.
Oh,
so you know.
Did not know that. So,
She does it in months, not years. Huh.
Okay, but for the purpose of the record, and to be consistent with what's in the information, count 1 is Class C with an enhancer. Initial confinement for Class C is 25 years. Enhancer is 6 years. So the total initial confinement, the maximum is 31. Extended supervision is 15. The total imprisonment for count 1 would be 46. I'm just going over the maximum. Is that correct for count 1? So it's Class C 25.
Yes.
And then the enhancer is 6.
Yes.
So that gives me 31.
Yes.
And then extended supervision is 15. The total imprisonment initial and so the bifurcated would be 46. Did I get that right?
Yeah.
I can't. Let me double check my math. That's why I always like to do.
Oh, come on. I can either make an Asian joke or a lawyer's bad at math joke. Don't set me up like that, Judge.
Yes, 46.
So you would prefer that?
And those are in years. So in months, that would be 552 months. Yeah. So if we were to break that down into months, it would be the total initial confinement with the enhancer is 372 months. Extended supervision is 180 days. And total imprisonment, the bifurcated imprisonment would be 552.
Yes, you just misspoke briefly. You said 180 days for extended
Oh, I'm sorry,
detention instead of
180
8
months. Yeah.
Okay.
There are no days. We do it in months here. And the reason why I do that is because the written explanation and determining sentence, I can do it in years or months, but sometimes, there are no years. So it's just easier if I do it across the board in months. That's why I do it this way. It's not to try to, unnecessarily burden anyone, but it's just easier for me to do it in months because of the worksheet I ultimately have to use.
That's fine. I'm just doing some calculations myself. Thank you.
Okay. And then, so State, you concur with the maximum as how I just calculated it?
Yes.
I think
Okay.
it was 30.
Then moving on to count 2, class H, initial confinement is 3, enhancer is 4, which takes us to 7 for initial confinement and years. Now, I'll first do years and I'll go to months, with the exception of count 3, that's a misdemeanor, so we're not talking years there. Extended supervision will be 3 years, and so total imprisonment or the bifurcated sentence maximum would be 10. And months, that would be initial confinement 36, enhancer is 48 months with a total of 84 months, and extended supervision would be 36 months, and then the total bifurcated sentence maximum would be 120 months. Count 3 is a class A misdemeanor, 9 months. And then count 4, beginning with years first, 7.5 years initial confinement, 5 years extended supervision for a total of 12.5 years imprisonment. Again, that's a class F. And then in months, that's 90 initial confinement, 60 extended supervision, 150 maximum for in months. And then count 5 is the same thing. 12.5 years maximum total imprisonment bifurcated, or 150 months total bifurcated, with the 90 and 60, 90 initial confinement, 60 extended supervision. Okay, so I think I did the math correct. State, do you concur with that?
Yeah.
Okay, and then Attorney Wasilewski, to ensure that the court is doing the math correctly, would you concur with all of that as well?
I would concur with all the year calculations. I haven't done the month conversions, but the years were corrected. I was following.
Okay. All right. So now that we all have that as a starting base, so that Mr. Olson, it's really for Mr. Olson's benefit, so he understands what the maximum is. But State, at this time, with respect to your sentencing argument.
Thank you, Your Honor. I just want to say one thing. I'm not going to talk about the facts of the trial in great detail. We were all here just last week going over the facts of the trial. But what I think is important to do is to fill in some of the gaps that were not talked about during the trial. And when I say that, for example, one thing that sticks out to me greatly was a discussion of why and some of the locations where Mr. Olson and Ms. Hannah were driving around the city. Detective Zaleski, and frankly, many other people in this community reached out regarding determining the identity of Mr. Olson. And so that is where I start basically this sentencing argument and why I think this is important as I talk about the seriousness of the offense, the character of the defendants, and the need to protect the public. As we all know, Ms. Hannah was, now we can say as the jury convicted, was abducted on the night before Thanksgiving in 2022. The next day, when she was recovered by police officers, again, this was a bit disturbing. The initial responding officers from Greenfield, and I've had discussions with them about this, truly did think for a moment that this was someone suffering from some of the more unfortunate effects of old age. But what we're all grateful for is that an investigation continued, that even Greenfield officers didn't just give up on this and walk away. As the story kept coming out, they realized that something happened, and the investigation carried on. So the next thing that happened in the investigation was that it was determined that Ms. Hannah's credit card was used not just at 1 or 2 locations, but a minimum of 5 locations across Milwaukee County that were discussed again at extent during trial. The video that was obtained from 2 of those locations that was shown during trial, that was broadcast through other law enforcement agencies and via the media. The media was also interested in identifying a case in South Milwaukee, which happened on November 17th, 2022. That case in South Milwaukee had Mr. Olson and an individual who is now deceased walk into a bar together, a drinking establishment. And it was shown on video and on the media that this individual, the victim, or not Mr. Olson, female, lost consciousness in the bar and later passed away. That image was also being broadcast throughout the media at the same time. This led to several tips of the identity of Mr. Olson, as he was, for lack of a better term, connected to several crimes, alleged crimes, throughout southeastern Wisconsin and into northern Illinois in fall of 2022. Some of the facts in this trial that were discussed and then avoided: there was allegations of Ms. Hannell being on the north side with Mr. Olson due to the purchase of illegal substances that Ms. Hannell told officers. Ms. Hannell and my investigating officers were directed not to talk about that because I think that that was not charged, but that was some of the allegations why there were many, many stops all over Milwaukee County for no discernible reason for the trial. But I think that's important context for Your Honor to have. Now, mind you, Your Honor, I'm talking about things that have not been charged. So, of course, I know that you will give them the weight to which they are due during this investigation. Additionally, it was discussed at the trial, Casa de Giorgio, where Rex Adrizi discussed Mr. Olson leaving without paying his bill. That was actually where several of the tips came from for law enforcement regarding the identity of Mr. Olson, as Mr. Olson had made a habit of going to an establishment, ordering a meal, and then leaving without paying. Many of these establishments, which was turned over in discovery, which, as you know, the state turned over a full copy of discovery, led to the identity of his face, of his features in these establishments. So again, this is all going to the character of the defendant and what he was doing. And I think that in this scenario too, he was realizing that he was closer and closer to getting caught, closer and closer to getting picked up by police, in which he was on November 29th of 2022. The other incident that I think leaves a lot of context out is, and was discussed briefly during the trial, was during the cell phone download. There were a lot of searches for Mr. Olson's mother's name, her in association with Racine Police Department, her in association with CCAP records. And that's because then on November 8th in 2022, Racine had investigated a death investigation because there was an individual that was found deceased in his mother's home after being out for a night with Mr. Olson. So this was another individual associated with Mr. Olson that ended up deceased in close proximity with meeting him and going out with him. And those are uncharged cases. Racine County also has 2 charged cases that I would also like to reference. These cases, Mr. Olson has yet to make an initial appearance on in Racine County, but they are first case number 22 CF 1503. Your Honor, this was referenced. There are 5 counts of personal ID theft for financial gain, where again, the allegations are that the individual was an adult that met Mr. Olson online, ended up going out with him, ended up being what was described as roofied, and then having her credit card be used at a number, well, at least at 5 charged locations in this complaint. Additionally, in case number 23 CF 43, conduct that happened on September 16th of 2022, this individual, again, was out with Mr. Olson, complained again of being given something which altered her mental state. That complaint alleges a number of controlled substances in her system, which she denies taking, and she was sexually assaulted. And that case is charged as a second-degree sexual assault of a person incapable of giving consent due to being under the influence or an intoxicant. Some of the allegations continued in identifying Mr. Olson. We had some individuals reach out stating they had met up with him regarding the buying and selling of illicit substances. It's just adds so much regarding his character, regarding the need to protect the public, regarding the effective rampage that Mr. Olson was on during this time frame. It's difficult.
Come on, guys.
concur with that?
Yeah,
Okay, and then
Your Honor, there's one
Optioning.
consequence that when we're in trial today, that when we're discussing the trial.
Hello.
Hey, what's going on?
Not much, you?
Not much. What do I miss?
We're watching, unfortunately, our boy got convicted.
Oh, I missed that.
Yeah.
So now what?
He's doing sentencing.
Oh,
I know. It's a
well,
bummer.
okay. Why are we watching sentencing?
For his antics.
Oh, okay.
He's already been kicked out and he's on Zoom.
Oh, he's on Zoom.
Yeah, they got it working.
Oh, really?
Yeah.
Okay.
Trial
At least
that
we might get
happened
a clear
last
picture.
week.
I'm sorry?
At least we might get a clear picture of him.
Kind
When
of.
we're discussing the victims from last week, there's one consequence that, to me, it's difficult to think about, and in a way that it doesn't come top of mind. And what I say about that is, as you know, Mr. Olson has an extensive criminal record. And I'll run through that briefly because I think it's important to have that during the sentencing argument. In 2002, he was convicted of possession of drug paraphernalia. In Racine County, in 2012, theft in Kane County, Illinois. In 2009, driver-operated vehicle without owner's consent. In 2007, a burglary in Illinois. In 2005, resisting and obstructing in Dane County. In 2005, possession of cocaine or controlled substance in Dane County. A felony theft conviction in 2004. A forgery from 1997, where he was convicted in 2000. A felony theft in Kenosha County from 1997. An escape from 1997 in Kenosha.
Escape?
A felony theft in Kenosha County from 1997.
Thank you, Ella.
An escape from 1997 in Kenosha. 2 counts of forgery uttering in Kenosha in 1994. And then when I reviewed with carefulness his in custody time through Illinois and Chicago, it is clear that Mr. Olson has been spending his time in custody by the installment plan, not having much more of a gap in custody than like approximately 3 or 4 years, several years in a row. And while I want to talk about his conviction now, is I'm bringing up specifically a case number 06CF5944 for 2 separate reasons. One, that case was discussed during trial because Mr. Olson stated, part of that was concealed because of misconduct.
Moments. I know you're a big fan of this guy. Do you know him from somewhere? I love the way you're sticking by him. I think that's really sweet of you.
His character also goes to the fact that he doesn't believe that your court defense attorney or I can fact check or inquire as to what actually happened.
Yeah, character evidence, old news. You can't drive well forward if you don't stop looking in the rearview mirror. He's changed. He has changed. This is old stuff. We know about all this. Move on already.
In that case, and while I think the reasons for that case being resentenced are appropriate for not being put on the record, it wasn't misconduct. It wasn't those allegations. And why I'm also bringing up that case is that our general DA mailbox received an email from the victim of that case, partially just discussing
railroading. This is 404 bad acts. I don't know why it's being allowed in, even at sentencing.
The trial as a whole, but partially discussing about the fact that even though this was 20 years ago, and she thought she had put this behind her, seeing Mr. Olson's face on television day after day after day, for now, Your Honor, it's been almost 2 weeks since he first claimed competency that he has been on the news and on the media and that she's sitting in her home and
Oh,
this
hey,
ends up
sorry for
basically
that.
invading her living room, about how this brings up
Great
her
to see you
past
here.
and how she is still to this day devastated, embarrassed.
I don't know how you keep getting in. Rule 404 of the bad action. You're not allowed in. I'm the one who's allowed in. I'm an exception. I'm allowed in. You're never allowed in.
And ashamed and in shock that she could have fallen prey to this evil person. She's brave for still being here, for reaching out, for discussing that. Every victim, every witness that came forward in trial last week to talk about what happened, to talk about their story, is going to have those same effects for a long time. I think it's important to bring up because this victimization isn't just a one-time done.
See, Ursula, we do need a Dr. John to evaluate him because, like, really, this woman, she can't opine. What's she doing opining? She's just a lawyer. She can't opine. She's not a clinical forensic psychologist.
This lasts with victims, especially when they're taking advantage of in this way for years. And I think, Your Honor, that's one of the reasons why the need to protect the public is so high and why the seriousness of this offense is so high. And I would like to discuss now exactly what I am asking for in months from each of the counts that Mr. Olson was convicted of. For count 1, kidnapping, and Your Honor, just to be clear, I'm going to ask Your Honor for consecutive sentences for each of these counts.
Oh, she's such a
They are all separate. They all have separate victims, are separate crimes with separate types of motivations by Mr. Olson. While counts 1 and 2 are the same victim, they are very different crimes with very different consequences. For count 1, I'm going to ask for 264 months in custody with 180 months of extended supervision. Count 2, 36 months in custody with 36 months of extended supervision. Count 3, 6 months in custody. And for counts 4 and 5, I'm going to ask separately. So count 4, 60 months in custody and 36 months extended supervision. And then the same for count 5. Frankly, Your Honor, this is as close to what the state believes a case should be deserving of for a maximum sentence. And the only reason I am not asking for a maximum sentence is 1, because Ms. Hannell was allowed to escape relatively unharmed, even though it has taken her years and years. Well, frankly, she states she still has a nightmare every night. Though that was her testimony. This is still causing her nightmare.
Did a clinical forensic psychologist evaluate her and look at her past nightmares to see whether or not she was having nightmares beforehand as well? Because she looks like the kind of old lady who would have nightmares anyway.
Every night. So I guess physically unharmed would be a more accurate way to put it.
8 months,
and
hours, and you haven't.
Regarding the burglaries, those types of allegations Mr. Olson's faced in the past, has been convicted of in the past. The only reason I'm not asking for a maximum sentence on those is that it was not the primary residence that was fully broken into. Although, of course, with the Endall home, that is part of what caused Ms. Endall, Christine Endall, to have such trauma, is that she could tell that her home was attempted to be broken into. And that was an incredible violation of her sanctity, her security, and how she viewed that residence that her and her brother were able to take care of. Your Honor, I think that this is truly described best as Mr. Olson is one of the most serious people that this court could prosecute. Taking a then 79-year-old woman throughout the city, causing her so much fear, as well as all of the surrounding circumstances, is why Your Honor should follow the state's recommendation. Thank you.
All right, thank you. We're gonna need Mr. Olson unmuted.
Oh, here we go.
But Mr. Olson, while the deputies come back there to unmute you, I want to let you know that there are factors for me to consider as sentencing. These factors include,
What happened? Oh no. Oh, wait.
I want to go back as to your history, touching upon your character, things such as your age, family, education, work history, and any history of undesirable behavior pattern or things that the court can consider relative to your.
Chat, do you think that the judge is going to be like very lenient towards him, considering how much she just loves him at the moment? Like she is so sympathetic towards Mr. Olson right now. Like they've been getting along like a house on fire.
Character, nature of the offense, any mitigating, aggravating factor, and then also the need to protect the community, which may include the need to protect specific individuals and or the community at large. But I'm letting you know that so that when you make your sentencing argument, you are aware of what the court must consider in fashioning a sentence. Okay, so Mr. Olson, as to your sentencing argument.
Well, so first of all, I'd like to object to everything the DA said, if that's possible. Some of the history is wrong, and as far as that case from 2009 in Milwaukee, it was changed for a reason. There was DA misconduct in their case, and the alleged victim never claimed that I stole a car, which is why I shouldn't have been charged. Again, if you could look at the charging document, I would borrow the car, we lived together.
I borrowed it.
That case shouldn't even have ever been charged. There was no crime committed, which is why my case went from 5 years to 3 months, and the judge let me out. I believe it was around 3 months serving that 5-year sentence, and let me out immediately because there was no crime. So everything is being kind of it's being made to look as if it is more than what it really was. And as far as this case, I mean, I've always claimed my innocence and that they're effectively exonerating me. I'm not
wait for that now.
That they're making it out to be. I'm a kind, caring individual. Anybody that knows me knows that, and I've continued to do that in jail, helping inmates. They can't read or write, file grievances, file other.
He's been helping inmates, like, you know, make hooch and fashion shanks out of, you know, paddle pop sticks and stuff like that. He's been really helpful.
These things just within the jail. Anybody that knows me can vouch for this. Unfortunately, I have nobody here today. This has been very difficult to defend myself, having 2-3 concussions within the last week.
People keep bashing me up.
And then no help from my standby. I was told he was going to be helping me and to take over for my trial if I couldn't go, but then wasn't allowed to do so. It's been very hard to defend myself. And again, anyone that knows me knows I'm a very kind person. This narrative you put out there is completely wrong. And as far as these allegations or investigations, I've never been charged with anything because I did nothing wrong.
Nothing wrong.
And that the DA was bringing up from other counties. And I still have not been officially charged with these crimes and Racine that she's bringing up.
Racist?
And again, for these counts, I've always maintained my innocence, and I wish Your Honor would take a look at those unredacted phone download forms that were falsely a file which proved that there was a text that exonerated me. I've claimed this since day one. I don't know why anyone would make a claim of that sort. And the DA has perjured herself. And so I hope that you take that into consideration. This person should have been charged with filing a false police report, which is why they kept this text. The DA knows she could never win her case if she gave up this text. This is why I've asked the FBI to get involved to prove my actual innocence. And as far as these other cases go, I said I knew those individuals. I knew the individual that owned the RV, and I'm not sure.
They let me shit in there.
I had a chance to testify, so I could be in my side of the story. I used to make deliveries to the individual that owned the garage, which is how I knew him, and I was not able to testify to that. I did Uber Eats deliveries to that individual, Instacart deliveries to that individual. There were numerous things I was able to testify about, which would have made clear more things about why I was how I knew them. But again, my innocence is I claim my innocence from day one. There are texts in the download. This is why she came out with another download. This is it's clear in the transcript, Your Honor, that she withheld the text. In January 2024, Attorney Camaraderie acknowledged receiving full discovery. And then in February 14, 2024, they revealed they had an unredacted phone download, which contained the text that came to my case. And this would also show the communication between my attorney and DA Olson. So I'm not sure why none of this was ever investigated by the OLR, Judicial Commission. I've contacted so many people, and even the FBI. I'm asking the FBI to look into this phone download. Oh. So and her Betty's phone record will show that text is there, but no one would subpoena the phone record by motion number 11. And it's
Mr. Olson, I'm going to interrupt you there because I've allowed you to go way off track here. I already told you what the court must consider as sentencing. And to the extent that I've already addressed your motions, try not to spend your time talking about things that really aren't relevant to sentencing. And even if it's relevant, it has probably very little, it's going to be given very little weight, okay? Because those are motions you can file on appeal, or issues rather that you can file on appeal. And so to the extent that the court's goal here as sentencing is to pronounce a sentence that, one, punishes you for what you've done and to protect the community, what are things that you want to argue on your behalf and make sure that I'm aware of?
Well, and that's why I was bringing up the alleged victim's phone records. If those simply would have been subpoenaed by any one of my 7 attorneys. That's one simple thing that I asked of my attorney. Can you please just subpoena
any one of my 7 attorneys?
He's not okay. He didn't listen. Just
none of them would do such a simple task. I don't understand why. So this pertains to my innocence. This is huge.
For God's
And
sake.
if those texts would have been handed over, the phone record subpoena that shows that phone call listening to the phone download, this blows the case out of the water. Oh, Mr. Olson's been innocent.
Okay, Mr. Olson, I'm going to interrupt you and remind you yet again, you cannot follow the court's rule relative to your sentencing argument. I think at this time it's proper for me to mute you and then proceed. So let that be your last warning, but please continue with your sentencing argument.
Okay, well, I mean, there's no reason to protect the public. I'm not violent. I'm innocent of these charges. Anyone that knows me knows I'm a kind and caring person. I'm innocent, so I guess I don't know how much of an argument I can make as far as what she sentenced me to the charge of sentence and innocent man to prison. I haven't been in any trouble since for 10 years. I know the DA brought up a case in 2002 that wasn't even mine. There were some cases that she's bringing up that aren't mine, but I don't remember all of them, what she said. But I mean, I'm not someone that needs to be, the public doesn't need to be protected from. I've been in the jail here 40 months. I had not one rule violation at all, and that's rare here. Not one fight, not one anything. Lock-ins are given here.
For any rule violation, I have 0 logins in 40 months. I'm polite, courteous to everyone, just like I am out there. You know, some of my past 20 years ago, I did have some issues that were drug related, and I always owned up to those. And if I pled guilty to the plea, I did own up to those crimes, and I paid my.
Oh my God.
And even more so, I believe I was overly sentenced on a lot of those charges when parole was taken by Tom.
Take it back over and skip him.
Then necessarily for some of those crimes which were.
Here, I'll give it to you. Goodness me. Dear me. Dear me.
Those are revocations that would apply to any other case than this one. So I believe he's entitled to continuous credit from his arrest date to yesterday, which would be 1,204 days. And I have prepared a form indicating that, which I can submit to the clerk.
Yes, please. I'll take a look at that.
I'm just gonna skip this
So you were on your knees
until the judge, because the judge,
testified.
it's pretty good.
Inflicted is without a doubt everlasting, as she herself testified at trial. The amount that were charged without authorization, without permission, I think in the big picture here, those amounts were not large amounts. Some of the items recovered may not have been returned to the victims yet, but nonetheless, they have been recovered. I believe the bike was recovered, correct, State, because that's when law enforcement observed him with a bike. The phone was tossed along the road, and that was recovered. That's correct, right? Yes. And so to the extent that those items have been recovered, eventually, probably at one point, those items could be returned to the victims. And so it's not a total loss in that regard. So those are the mitigating factors. As to the aggravating factors, the victim here, one of 3 victims, but the first one, Ms. Hennel, she was 79 years old at that time. And I know that there was evidence that was brought in by way of testimony indicating that today her mobility is much more limited than it was back then. But nonetheless, she had limited mobility. And for at least 15 hours, you held Ms. Hennel against her will, without her permission. You held her captive, and you inflicted emotional and psychological trauma. The one thing that has stayed with me to this day is when Ms. Hennel testified and explained that during the time that she was with you, Mr. Olson, she thought about how to escape and whether she can escape. And for someone in that moment to know that the door is also close, like freedom is so close, but yet not within grasp. She couldn't trust herself that she could get away from you. That emotional, psychological trauma, I just can't imagine the depth of that trauma. But to this day, and through her testimony, that still haunts her. In addition to that, she, of course, herself testified that on a daily basis, she relives this incident and is able to recall this incident. And so the harm that you've inflicted on her is extensive, no doubt. I don't doubt that for 1 minute. But what was, I think what was disconcerting, and I think at a greater level, emphasizing the need to protect the community beyond the 3 victims in this case, is the fact that when you subjected Ms. Hennel to this harm, and she tried to flag down help, that the first person who saw her told her that that person could not help her because they had a turkey in the oven. So she was turned away from help when freedom.
I never think that's real.
There's a lot to blame this guy for. But I'm going to go ahead and put some blame on the guy who had more important things like a turkey in the oven than helping a freaking kidnapped woman. Maybe he should get a little shame too. I'm just saying. Oh, I guess I'll flag down. I really got to go, ma'am. I know you've just had a horrific ordeal. I know you were forced to pee in an alley. You were abducted, traumatized. I got a bird in the oven.
Mm-hmm.
I guess I'll flag someone down. God, you know how women are. I ain't passed her on to the next schmuck.
Was so close and yet turned away. And I'm sure that reinforced her belief that she could not escape. So it made it so much more.
Way to go, turkey guy.
Persuasive. Why she felt so helpless and hopeless. Because in fact, at the end, she was refused help because somebody had a turkey in the oven.
it's just beyond words. The
I'm really glad someone called
The
that out. Because when I first heard that, I was like, that is atrocious. Look, I've had prime rib in the oven and timed it down to the degree. I understand the necessity sometimes of getting home and getting your food and your big meal and all that fun stuff.
Mm.
I'm OCD when it comes to cooking big dinners like prime rib. Okay? You got a fucking grandmother there who's just abducted, or she has dementia and Alzheimer's and has no idea where she is. Either way, you can spend a few minutes there. You know, I'm sorry your turkey's going to be a little dry. Or you could just call
Any
your...
reference to turkey in the oven just sounds like it's something else to me.
I know.
Yeah.
He had to get home and stuff that bird.
Yeah. This doesn't sound right.
harm that you subjected this victim to. And on top of all of that, you talk about your mother. Miss Hennell is someone's mother as well. But that consideration you did not extend to Miss Hennell. And that emphasizes how important it is, the need to protect the community, because you cannot extend that reasonable consideration to anyone else in the community but yourself. That puts the community at risk, and it puts the community on edge. You used the victim's phone, then you discarded it. You used the victim's bank card, and it was found on your person. You made purchases without permission, albeit I did count as a mitigating factor the fact that the amounts that were charged were more or less nominal. But
it's a mitigating factor. You didn't steal too much money from the 79-year-old woman.
That's fine.
Yeah,
That's
you
okay
robbed the
then.
grandmother, but you didn't rob her of that much money.
Nah,
Sure,
it's
you kidnapped
fine.
her for 16 hours, but you only stole a little bit of money.
Well, she didn't
That's
have
about
much,
that's
to be
that's
fair.
okay. You know, that's kind of like death level defense attorney mitigation arguing there.
Mm-hmm.
Yeah, he brutally raped and murdered a woman, but he didn't steal any money from her. He left all the money.
nonetheless, you had no permission to use her bank card. You enter properties without permission. You damage property in the course of doing that. You defecated in someone's RV when that RV had been winterized. All that takes time and money.
What the hell is winterizing
Hey,
an RV,
winterized.
by the way?
What does winterize mean?
I mean, I understand it's like preparing it for winter
Oh,
and protecting it during winter, I guess. But I have no idea what that entails. I mean, I assume it doesn't entail shitting in the toilet, but
And also, when law enforcement approach you, and I forgot the word exactly that the officer used when he testified, but I'll just basically describe it as quiet resistance. You were on your knees, but you failed to, and you refused to fully follow the instructions, which is not inconsistent with your behavior in court. When I asked you if you can follow the rules, you would give a long statement before you would say, well, I guess, well, you're the boss. It's a yes or no, and you know that. But that's consistent. That behavior is consistent with the resistance that you gave to the officers on that day. The amount of resources used by you, not just with one jurisdiction, Greenfield, but you extended that to Franklin. And those resources could have been used to address important needs in the community, but yet because of your criminal conduct, your criminal mindset, that you unnecessarily used up all those resources. Considering all these factors, the court will sentence you in the following way. I agree with the state that this has to be a consecutive sentence because each offense is a distinct harm that you've inflicted on the community, and it has to be recognized for that. With respect to count one, initial confinement, 240 months, extended supervision, 180 days,
including right now.
consecutive to any sentence you may be serving. Count two, 36 months in, 36 months out, consecutive to count one. Count three, 9 months, that'll be consecutive to count two, and that's 9 months in the jail, but the DOC will do its math on that relative to your placement. Count four, 60 months in, 36 months out.
and that's consecutive to count 3. That's to count 5, 60 in, 36 out, consecutive to count 4. You're not eligible for boot camp by virtue of your age, but you're not eligible for programming additionally. And so that's the 4th sentence. As to conditions of supervision, they are as follows. AODA assessment and comply with recommended treatment.
Basically, he gets 33 years. So that is the story of our boy Timothy Olson.
So the 33 years is for the kidnapping, basically.
And the other stuff too. It's all consecutive.
Well, what other stuff, really?
Robbing, breaking into the RV, shitting in the toilet.
Wow, that's a lot of time.
Yeah. Well, she did it consecutive and gave him the max on everything she could.
Jeez, don't represent yourself.
Yeah. How old is he? 40s? No, he's born in 1970. So
More.
56?
Yeah,
Jesus.
close to 60.
Plus he's
But wow, that's
awesome.
a fuckload of time.
Yeah, he fucking traumatized her. Kidnapping.
I get it. Like, I mean, no, I get what the gravity of what he did. It's just it's 30 something years.
Oh, yeah.
Wow. That's like murder.
Yeah.
Wow. I mean, like, you don't get that much here for murder.
No.
Yeah. I mean,
Not unless you make beef Wellington.
yeah, wow. I mean, if you make beef Wellington, you're in big trouble.
Oh, yeah.
Mm.
So what do you have coming up?
I'm going to be popping around a few streams today as a guest.
Very cool.
I am going around and guesting today.
Mm.
Today is my guesting day. So I'm not revealing where I'm going. You're just going to have to follow me.
Sounds good.
Going to gate crash.
Got any streams this weekend?
Yeah, probably tomorrow.
Okay, cool.
But I haven't exactly decided what. But I might do a little bit of a review of this whole juror situation. There's a juror that's spoken to Nate, and then there's this other. Well, I haven't looked at the 2020 thing. Have you guys seen the 2020 thing?
I just saw the preview for it.
Yeah, no, I haven't seen the actual, because it came out tonight. It was supposed to be Friday night, so it should be out now.
Well, tonight's Friday night.
I know. I am aware what night it is for you.
Well, at least one of us is.
Yeah. So I was going to have a look at that later today, which is your night, and see what was in it, and if I can clip some of it without getting copyright struck. It's on tonight, Half Irish. Yeah, I don't know if it's been on yet. It's a later show, right? Yeah, I think it's 10 p.m. or something.
Yeah.
So yeah, I might see what I can get out of it without getting struck. But yeah, that'll probably be tomorrow. I'll probably do a live on that tomorrow if that's what I feel like going live on.
Yeah.
Unless there's something else juicy. There's many juicy things happening on the internets at the moment. I'm just deciding which one.
Yes. We wouldn't want to offend anyone covering the wrong subject.
Oh, we could though. That would be fun too.
Oh no, yeah. Us offend someone?
Us?
Us have a controversial opinion?
Never.
Criticize someone? Be attacked for it?
No.
And then proven right?
And then proven right? Never. Shut up.
Well, gee, Wally. Who could have predicted that?
Don't be passive aggressive.
I'm taking the high road here.
You are not.
No. If I was petty, I would be responding to every single person. The dozens and dozens and dozens of angry comments we got. Responding personally to each and every single one. I still may, but I haven't as of yet.
Well, they're all on my channel, so don't.
I know, I won't.
I don't think chat's got any idea what we're talking about. So.
No.
Well, they might, but we're just gonna let's
Whatever.
just leave it there, shall we?
Yeah.
Yeah.
I'll take the high road.
You started this, you know.
I know I did.
Yeah. You started this, and
It
now
was
you're
my
thinking
fault.
about going into my comment section and causing more shit.
Well, I was gonna do the stream, and then I was like, "Well, you can take it if you stream idea." He's like, "You can take it if you
No,
want."
you never said that you were gonna do the stream.
No, I said I thought about it, but then I was like, "Well, if you want to take it, you can go ahead and stream."
For fuck's sake. Jesus Christ. Welcome to our lives, everyone.
I know.
Uh-huh.
All right, guys,
You
I'm
know
gonna
we're
end
still
now.
live. You know we're arguing and we're still live, right?
This conversation would be the exact same if the stream had already ended, quite frankly. So
It would.
we really are the same backstage as we are on stream.
Yeah. Exactly.
That is
true.
the one thing with us is we are like what we show is 100% genuine.
Yep. Afro Man plaintiffs were worried what people in Australia thought. I saw that.
Really? I can't
I saw
imagine
that. Yeah.
anyone worrying about what people in Australia think.
Okay, so that disgusting cop, whatever his name, the white, shut up, the white,
There you go.
that super duper white cop, the one whose brother was a PDF.
Oh yeah.
Yeah, he was like, so the Afro Man's lawyer goes, so are you concerned about what people in Australia would think of you if you were called a PDF? And he's like, yeah, I would. Yeah, I'm worried about that.
Why did they
And
bring
I'm
up
like, I was
Australia?
in Jolene's chat. I was like, we wouldn't let this man in anyway.
Hey, bye, Franz.
What's up, bye, Franz? Bye, Franz. How's it going?
Yeah. How you been?
See you for a while.
All right. Well, I am gonna end now. It's been a lot of fun, and I shall see you guys later this week. And what?
Nothing. Just don't cause any trouble, right?
I won't.
Okay.
I'm a good boy.
Yeah.
Bye, everyone.
Goodbye.